Today I come in front of all my followers right throughout the country to bring you to the drama at the courthouse. The State versus Yafai case was brought before the Chief Justice Gibbs Salika, and Gibbs Salika ruled that he would the application to dismiss the case was rejected and that it would proceed to trial. I wasn't there at the courthouse and I don't even know the full details of the case, but on assumption and from press reports, it's related to the 40 million plus payment to the firm Paul Paraka and lawyers firm back in between 2012 and 2013 when O'Neill was Prime Minister and James Marape was his Minister of Finance. And this case is very interesting simply because of a precedent case in the past when a Minister of State by the name of Paul Tienston was taken before the courts, and he was sentenced to imprisonment with hard labor for 10 years for having scribbled a footnote requesting the secretary to make payment. Now, the State versus Yafai case hinges on the fact or the provision of the Public Finance Management Act, Section 32, which is the powers for approval of requisitions for payment. And it is very clear that the Section 32 officer is the head of the department or his delegate. His delegate meaning his deputy secretary or whoever he appoints as the Section 32 officer. So there is no doubt that the secretary or the acting secretary, Mr. Yafai, or the deputy secretary was acting secretary at that point in time, had the powers. He had the powers under Section 32 to approve payment, which he did, according to the prosecution, which said that 40 plus million were paid into Paul Paraka's account. And Mr. Yafai can't deny that unless he has proof otherwise that he didn't sign the requisition for payment. The question now is whether he had that whether that payment was legal or illegal, or lawful or unlawful, and that goes back to the the contracts that were in place, where the Attorney General's office or the Sol Gen had procured the services of Paraka lawyers, and I think his lawyers, Mr. Yafai's lawyers, had presented this case before the Chief Justice about how and where Mr. Yafai had derived his powers to make those payments, which have been found to be fraudulent by a colleague judge who sentenced Paul Paraka to 20 years imprisonment in Bomana for having received funds that were found to be unlawful, implying that Paul Paraka had never had a legal contract in place to provide pro bono or free services to remandees and prisoners right across the country, and that if he had done so, without the approval of the officer, the Department of Justice, and they didn't even require services, so to speak. Although we can say that he had done a marvelous job, he had done it outside the requirements of the Public Finance Management Act. But there is an interesting twist to Yafai's counterclaim, stating that he was coerced or forced into making those payments on the insistence of the Minister of Finance. Now, the Minister of Finance, we must all be clear, is not a Section 32 officer, meaning that he has got no financial powers to approve any requisition for payment. If the requisition for payment came before the Minister of Finance, he could not footnote it or direct or do anything because he didn't have the powers of requisition. But to the contrary, the Minister of Finance at the time was now the current Prime Minister, and the Prime Minister at that time was implicated in that he had written a letter instructing the officials to make payment, which he denied earlier, stating that it was fabricated, and that has gone before forensics, and that I think the court had dealt with it. Although he had interfered in the process by getting a stay order for the police not to obtain a warrant of arrest against him. But in the case of the current Prime Minister and the former Finance Minister, who wrote explicit instructions to the financial delegate or the secretary of the Department of Finance or the acting secretary or whoever, that they had to peruse and verify and make payment. And he had signed that letter. Although he's not a Section 32 officer, where he cannot, his signature cannot culminate in any payment, he had given specific instructions. And these instructions was an effect on the secretary or the acting secretary. The deputy secretary was acting secretary at the time, to make payment for one reason only. You know, as minister, he had the authority to remove the Secretary of Finance and put another secretary in his place. And that has been done and could be done again, where political pressure is applied on public servants to do what they don't wish to do. But that again is hearsay. It can be proven whether he had pressurized whether he had applied any pressure at all or threats, or whether he had intimidated the deputy secretary and acting secretary at that point, Mr. Jacob Yafai, to make payment or not. It's all hearsay. But what he did do was to sign specific instructions on a finance minister letter to the deputy secretary, who was acting secretary at that time. Mr. Yafai was the deputy secretary and acting secretary. So it calls into question as to how and why the police, prosecutors, and the commissioner of police had made him a state witness against the evidence that he had actually signed a letter directing the deputy secretary or the acting secretary to make payment on the Paraka claims. He had absolutely no powers. He had no powers to do so. Even if he had signed his directives, the deputy secretary or the acting secretary, Mr. Yafai, did not write according to what we see, what has transpired. Mr. Yafai at no stage responded in writing explaining the facts that he could not process payment. Now this brings us into the possibility of a conspiracy. A conspiracy meaning Mr. Yafai could have whispered to the minister that if you have something in writing, I would act on that. But if you didn't have anything in writing, I wouldn't act on that. Now the recipient was the law firm, Paraka Lawyers. And the transaction was done in paper checks, meaning finance had paid paper checks to the Paraka Lawyers accounts. It was not paid in cash. They did not count cash over the counter. The finance department paid the 40 million plus in checks to the Paraka account in the banks, wherever he banked. But it was paid into that bank. So the question we are asking now, and as president of the People's Anti-Corruption Movement Incorporated, which is a legal entity, a civil society organization, and we have taken particular interest in law and order cases. And in this instance, we have written a letter to the police commissioner on the Friday, 2nd of February, 2024, complaining to him that he should process and arrest interrogate the former finance minister and prime minister at that point in time as to why he had given directives to the deputy secretary to make payment. Now, to this date, the police commissioners ignored our letter, and we proceeded to the courthouse and we have filed a summons, OS number 52 of 2024, against the police commissioner, for him to come to court to show cause why he could not prosecute the former Minister of Finance and the current Prime Minister. We have done so to restore the rule of law in Papua New Guinea. Now the police commissioner cannot give excuses that he did not have sufficient information to process the Prime Minister, because I think in 2015, Parliament had passed the Proceeds of Crimes Act, which empowers the police commissioner to investigate the money trail. And whether he had deliberately ignored that particular provision or that he opted not to prosecute the Prime Minister is something that he can only tell the court. But had he complied, had he acted on the criminal complaint, and had he applied the Proceeds of Crimes Act to prove, since Paraka's appeal was quashed and that he was convicted to prison for 20 years, the police commissioner had all the time and all the resource, and he had the legal authority to investigate the money trail with the Paraka law firm's account. After investigating the accounts, he would have tabled it. He would have tabled it to the public, it would have given this, it would have attached it as proof that the benefits of that payment did not end up in the wrong places. Meaning that the proceeds of the payment made to Paraka did not rebound back to Yafai or the Prime Minister, who was Minister of Finance at that point in time. Now we've got that summons to the Commissioner to come to court to table the Paraka lawyers' accounts, because we are pretty sure that the police investigators have got records of all the Paraka payments from his bank account. Nothing stops the police from doing search warrants on accounts that are dubious or that have violated the law. They have all the right to obtain search warrants to go through all of Paraka's payments. And like I said, I keep repeating, he was not paid in cash. So from all his payments, the Commissioner was supposed to apply the proceeds of crimes account to take back the state money by forfeiting properties that he may have paid, or by looking into where he had invested the money, and they would have used the proceeds of crimes to take back the money. But the police department and the police commissioner decided against it, so to speak, up to this point in time, by making the former finance minister and current prime minister as state witness. And there was, what could the prime minister say in defense? Whether he objected to the payment? And there is nothing in black and white that says that he had objected to the payment of the to Paraka lawyers. And even then, he didn't have the powers to do that. The authority that would have farmed the legal service contracts would be the Solgen's office. And the Solgen's office have denied any involvement in the authorization or the farming of legal services to Paraka lawyers. So where does that leave us? We can conclude by saying that this was an unlawful payment that involved conspiracy between all parties. All parties meaning that if the Deputy Secretary or Mr. Yafai was not seeking advice from the Solicitor General and had proceeded to use his Section 32 powers for the approval of all requisitions, meaning that a claim was put into the Department of Finance for 40 million plus. Examiners had gone through that claim, and whether they were satisfied that it met the requirements or not, it was finally done, given the approval, and brought up to Mr. Yafai as the Section 32 officer under the Public Finances Management Act, and he had signed knowing very well that there was no contract between the Department of Justice and the Paraka lawyers to undertake his pro bono services. He may have an agreement in previously, but at that point in time, he did not have the contracts in place, and his claims were not rejected. They were honored and they were paid out of the Department of Finance. And the decision was solely made by Mr. Yafai himself without consulting, without getting the approval of the Solicitor General's office. And that is a clear indication of culpability, and I think all other evidence was presented, and Paraka was given 20 years in prison, and his appeal was rejected by the Supreme Court. And I don't know what the law says. He might now appeal to an international court, but that remains to be tested. But as it is, it is obvious that Jacob Yafai is culpable in the sense that he is the requisitioning officer. It's the Section 32 officer that approves all requisitions, and he did so. But without the approval of the authority, and the authority was the Solicitor General and the Department of Justice, who are adamant that they had never, ever given any legal service contract to Paraka lawyers. So, where are we? Where are we now? The question is, did Jacob Yafai act alone? Of course, evidence tendered in court is that the finance minister at that time, Honorable James Marape, had written instructions to Mr. Yafai saying that peruse, verify, and make payment. And additionally, identify funds and create an account to solve all court matters. Yes, correct. He done that as minister responsible. But there was no court order ordering the state to pay Paraka. The courts did not issue any order or a mandamus saying that you have to pay Paraka for Mr. Yafai to act on it. And Yafai did not write in black and white responding to the minister that space Section 232 powers to requisition. He could not approve payment because there was no order from the court, and neither there was any agreement with the or contract with the Office of the Attorney General or the Department of Justice, who farm out the legal service contracts to lawyers. So there we are. It's going to be a landmark case, but whichever way it goes, as president of the People's Anti-Corruption Movement, we obtained a summons for the Commissioner of Police to show cause why he could not process the minister and current Prime Minister in accordance with the law, in that he had authorized payments. And if he did authorize payments, what was the motive? What was the motive for him to act outside his powers as minister responsible? He would have written this letter. He would have written this letter to the Solicitor General and copied it to the to Mr. Yafai as the acting Secretary of Finance, or the Deputy Secretary, Acting Secretary of Finance. And that would have made sense. He hadn't done that. He had taken the law upon himself. And Mr. Yafai had colluded and collaborated to make payment. He took the minister's letter as authority in this case. And we are now looking at the prosecution of this matter. The prosecution of this matter is that the police commissioner had not used his powers under the Criminal Code and the Proceeds of Crimes Act to table the investigation into the Paraka lawyers' accounts. And whichever way the case goes, whether Jacob Yavai is guilty or not, as the Section 32 officer responsible for all approval of for the approval of all requisition, or whether the Prime Minister had objected to the payment or had authorized the payment without having the powers to do so, is something that only the court can establish. But the Commissioner of Police has to come to show cause as to why he appointed the Minister for Finance as a state witness. Because there was absolutely no record to show that the Prime Minister and former Minister had objected in writing, in black and white, and yet the Minister had never written to the Office of the Department of Justice, and had never written to the Solicitor General for clarification to approve payment. Now, under the criminal code, that's an abuse of office. It's an abuse of office by the Minister or the Minister of Finance, an abuse of office by the Deputy Secretary and Acting Secretary of Finance, Mr. Yafai. And also, I would quite confidently say that the police commissioner has also abused his office in not investigating the money trail of the 42 million kina. Bank records will reveal exactly who got paid, whether Mr. Yafai got any payment in cash or in kind, in anything, whether the finance minister or the former prime minister got anything. It is not for Paul Paraka to say so, because he's a prisoner. Anything he says will not be taken as truthful. It is the onus is on the police commissioner to establish the facts, whether there was a conspiracy to defraud the state or not. And with that, it will be very interesting as we all await the outcome of the Yafai trial next week or the following week, whenever, or next month. And let me address all my followers right throughout the country. The People's Anti-Corruption Movement is all about the restoration of law. In 50 years since independence, we have simply drifted away from the rule of law. I keep saying, the founding father of this country and the longest serving Prime Minister and the longest serving Member of Parliament in Papua New Guinea and in the Commonwealth of Nations is the late Grand Chief Sir Michael Thomas Somare. Now, after 50 years, and if this country is falling apart, it is simply because our leaders have left behind a very sad legacy of corruption. Of corruption meaning that they have simply gone bush. They have deviated from the rule of law to use our customs, our traditions, and to compromise upon compromises to do things that are contrary to law. And the People's Anti-Corruption Movement has solemnly promised to all its members, and we are still waiting for members. We have a population of 10 million people who are also absorbed in corruption, and therefore you are avoiding all and anything that we say on our Facebook page, we have a following of only 1,400 people. And on record, we have 1.4 million people who have access to cell phones, according to statistics provided by companies like Digicel and B-Mobile and Vodafone. We have 1.4 million users, and they are not following us because they can see us, but they have decided that corruption is the best way of thriving in Papua New Guinea. And while you people who've got the education and the knowledge are thriving and benefiting from corrupt practices, there are 9 or 10 million people who haven't got access to that, who are mostly illiterates and people that are not in the books. They're not even registered as citizens of this country because their NID doesn't work. These people are the ones who are suffering. And the elites of this country have compromised the rule of law and have followed the political masters, and they're on the queue to steal more from public taxpayers. So if you are watching me and you think that you have something to contribute to this country and want to do anything good for this country, you better subscribe as a member of the People's Anti-Corruption Movement and follow our page to make sure that your community is safe so that you enjoy your life. Otherwise, we are all going to be impoverished and we're all going to be poor. We're going to live in a lawless country, and you're going to scream out that there is no rule of law in this country because you are to be blamed for the ignoramus you are in not speaking up and standing up to the rule of law. Thank you for watching me today. John Ndemongo Kua, President of the People's Anti-Corruption Movement, Incorporated. With that, we'll keep you updated on the developments at the Waigani Courthouse on the State versus Jacob Yafai case in the next couple of days. Thank you very much.